Does either of you have any questions for me before we open up the live?
Your Honor, we are live and recording.
Okay, we continue our hearing list this morning with the first of our two cases heard on the Zoom video conference platform. The first case is case number 2020 P53, the Commonwealth versus SWANIE J. Burnett. Mr. Lovins, you may begin.
Thank you. Good morning, judges of the appeals court. This appeal implicates appellate issues in two cases that were joined at trial. One of them is an assault involving a gun, and the other one is carrying a firearm without a license. And there are four separate issues I wanted to take up, although I may not have the time to do that. And so I just wanted to say up front, if I don't get to something, I'm not waiving the argument, and I'll rely upon my brief for those arguments. Insofar as the motion for required finding, the defendant is asserting here that the evidence was insufficient for the Commonwealth to have proved, beyond a reasonable doubt, of course, what they needed to prove.
As far as the elements of the crime, counsel, are you arguing that it was the identification element that was insufficient, or other elements of the crimes too?
Not other elements, Judge, no.
So wasn't the victim's identification of the defendant as the man who came up behind him and shot him sufficient to prove his identification?
Well, that's my argument. One of my arguments here, Your Honor, that was insufficient for a number of reasons. First of all, there was no identification at trial. Secondly, there was an identification in a photo array 35 days later. He marks on a photocopy of the photo, the statement 100% certain, and the affidavit of the expert says that certainty on identification is not relevant. And that's an issue that we raised on the motion for new trial. So there is that. There is also the confusion on how the defendant was dressed, described in the bolo, and the fact that the girlfriend failed to identify the defendant in the photo array at all.
So what do you say to Judge Ferreira's memorandum in order saying that trial defense counsel, Mr. Dunphy, did in fact use those details to his advantage at trial?
Which details, Ron? I don't.
Well, the inconsistencies in the color of the shirt and the fact that the girlfriend didn't identify the defendant, and toxicology report showing possible presence of opiates and cannabinoids in the victim's blood. and the traumatic nature of his, the event. The judge said that defense counsel was aware of all those variables and how they might bear on identification. And that while an eyewitness ID expert might have elaborated on some of those variables, the expert would also have been subject to cross-examination by the prosecutor and would have given the prosecutor the opportunity to draw out all the things the police did right.
I thought that was a very interesting statement that the judge made in his decision, that the expert would have been subject to cross-examination, because the response to that is, aren't we all? And sometimes through cross-examination, the witness actually comes out looking better. And I thought it was a rather odd statement, to be honest with you.
Mr. Lovin, so isn't the effect of the argument that you're making to establish a requirement that in any case where identity is placed at issue, it is a requirement to have an identity expert?
No, I'm not making that argument.
Well, I know you're not making that argument, but isn't that the effect of, if we were to agree with the argument that you are making, isn't that the effect of such a holding?
No, I don't think so. And the failure to have the ID expert on board and at trial is really more a part of my ineffective assistance claim.
I understand that, but the point is that if counsel is ineffective for not calling an identity expert, then any case where counsel doesn't call an identity expert is going to be vulnerable to an ineffective assistance challenge.
Well, it may very well be, but this was not taken in isolation.
That's my point. My point is, if we view this case not just in isolation with the specific argument that you're making, but view the implications of the argument that you're making, it is tantamount to creating an absolute categorical requirement for an identity expert wherever identity is placed at issue, on threat of having a claim of a valid claim of ineffective assistance counsel.
No, I'm not arguing that at all, Judge. On my motion for new trial, what I'm saying is that it was ineffective not to have that expert, because I believe, given the affidavit, given the strength of that affidavit, I believe that the defendant was in fact denied a substantial defense. You know, the victim never saw the defendant, for example, before he was shot. There was a brief observation in the restaurant, but the victim was actually trailing everybody else. The shooter went out first, then there was the girlfriend, then there was the victim.
No, but there were a string of circumstantial indicia that tied the defendant to the attack. The fact that he had a hostile encounter, the fact that he was found in possession of a gun that was a ballistics match to the shell that was fired. So, you know, that's the stuff of identification and in many trials.
Well, as far as the gun being involved, that's only as a result of what I believe was an impermissible joinder, because there was not present the classic grounds for joinder.
If the case were tried separately, wouldn't the evidence of the gun come in at the trial for the evidence of the shooting?
It may, but I think the rule is that the evidence of one would be admissible in both cases. So in other words, the assault evidence would be admissible in the gun case.
Right.
And And I don't think that's necessarily so, because the assault case has its own facts, and the firearms case has its own facts. And so I'm not sure that it would be, one would be admissible in the other. Do you want me to continue? Or do you have some more questions?
No, go ahead. Please continue with your presentation.
Okay. So with regard to the identification issue, the victim testified that he felt forced by the police to participate because he didn't want to be a snitch. Didn't want to be a snitch on the street. He was there after midnight, which invokes the fatigue factor, and there was a 35-day delay, as I previously pointed out.
But isn't it possible that trial counsel made a strategic decision to let the victim testify to the ID, not move to suppress, and try to make it seem like the victim was overeager to identify your client? And maybe the police weren't telling the jury everything, or the victim wasn't telling the jury everything, because maybe there was some reason why this victim wanted to identify this defendant. Couldn't the defense attorney, an experienced defense attorney, try to portray that to a jury, maybe better?
I'm sorry.
Without moving to suppress?
That's an interesting observation. And it's one which the trial judge tried to point out, i.e. that some of these things may have been strategic decisions. Interestingly enough, when I spoke to, and this is in my affidavit, when I spoke to trial counsel, he said absolutely nothing about strategic decisions. The only thing he said was that when I asked him why he didn't hire an ID expert, he said, because I didn't think that the law of identification experts, or the law of identification, one or the other, it'll be in my affidavit, had advanced far enough. And I just think that's absolutely wrong. But that was his only response. So there was no question of strategy that was involved. And I know that every time or any time I have an IAC question, which is not something that I like to raise in an appellate brief or on a motion for new trial, that I always give the trial counsel an opportunity to tell me that. And the trial counsel certainly did not take that opportunity.
Well, this case was tried in 2017, which was before the Supreme Judicial Court decided Ayala, about where they talk about strategic decisions to hire or not hire an identification expert. Maybe trial counsel was right. And I noticed that Ayala was a Hampton case.
I think that the issue of strategic decisions arises more so in the context of the law on ineffective assistance of counsel. And if I remember correctly, I believe it comes up in the Shaken Baby case, which I think was Milliken or Millian out of Middlesex, and or maybe earlier. But I believe that's where they talk about strategic decisions. And it didn't seem to me like it was part of the thinking of trial counsel in this case. I mean, certainly Certainly, if he had made a strategic decision, that'd be a different story. But there's no indication here that he did, just because the trial judge in writing his decision articulates that he did or he may have. Because one could say that in any case of ineffective assistance.
Blevins, you have more to tell us?
Well, just very briefly on the joinder. I don't think that the judge exercised his discretion at all, and I said so in my brief.
Well, we can look to your brief then for that question. Thank you very much for your presentation.
Thank you.
Okay. For the Commonwealth?
Good morning. Good afternoon. Travis Lynch, Assistant District Attorney for the Commonwealth. May it please the court. Just to go directly to the ineffective assistance of counsel claims raised on the motion for new trial, and to go to the failure to retain an eyewitness identification expert issue. I think the Chief Justice is exactly right, because if you were to say counsel in this particular case was ineffective for not calling an expert, that would basically create a categorical rule. And in Gomes and in the Gomes case, of course, the SJC requires that the jury be instructed about eyewitness identification issues. And then later, the SJC promulgated the model eyewitness identification instructions. I believe that was in 2015. And as I pointed out in the brief, and as the motion judge pointed out, the judge gave the model, or gave excerpts from the model eyewitness identification instruction in this case. And I think on the facts of this case, as I read the defense expert's affidavit, I really didn't see, there wasn't really much new. I don't think there was anything new in the affidavit. So if someone had testified to what the expert put in her submission, it's really nothing new, nothing that was not already before the jury in the instruction, and also in terms of the cross-examination and the arguments made by counsel. To address, I thought that Justice Grant's point about Ayala was interesting. I would note, for what it's worth, Ayala was before Gomes. And at that time, I think it wasn't common for defense attorneys to put on eyewitness identification experts. So Ayala is a pre-Gomes trial. This was a post-Gomes, post-model instruction trial. The appellate counsel's affidavit regarding what trial counsel said was at volume 1, page 70 of the record appendix. And I think the trial counsel is reported as saying the law of misidentification was in flux at that time. I don't really think that was really accurate, because I think the model instruction sort of settles things. But again, the defense attorney put on the eyewitness identification defense. The cases in which counsel was ineffective for not talking or not consulting with an expert are cases like Million, which is, I believe that's the shaken baby case the defense counsel was referring to earlier. Other cases that I cited in my brief are such as Labrie and Hegarty. So the defense was fully presented. The expert would have added nothing. I think the other issue I wanted to briefly mention on the ineffective assistance of counsel claim was the failure to move to suppress the identification. As the motion judge noted, Mr. Sterling was shown, it was apparently hundreds of photos, 12 images per screen, and the Silva Santiago warnings were given. There's no way a motion to suppress would have succeeded, because this was not a suggestive identification procedure. And I don't really, and I believe that the other issues I think are fine left to the briefs, unless there are any particular questions about anything.
Being none from the panel, I will leave it there. Thank you for both for your presentations. The case is submitted.
Thank you, Your Honor.
Thank you.
Thank you. All right.
We are recording and live on YouTube.
All right. That brings us to the final case on our list for hearing today, the second of our two Zoom hearings, case number 2020 P847, the Commonwealth versus Gregory R. McNeil. Ms. Merrill, you may begin.
May it please the court, I'm Dale Merrill representing Mr. Gregory McNeil. The first issue I'd like to address is the fact that there's a problem with the jury veneer here. The current methodologies for determining if Black Americans are systematically excluded from participation in juries and whether Black defendants get a fair trial sets a near impossible bar to protecting their fundamental constitutional rights. Here we have a situation where the judge and the district attorney admitted that on any other day in Middlesex court that the juries were going to be predominantly white, that Black people were not represented in the jury pools in Middlesex County. The judge did refuse to decide whether 1 out of 60 represented an appropriate racial makeup of the community or not. However, if he had walked outside the door and gone to go get a sandwich at Demoulas, he would have been able to see what the racial makeup of the community is. There are a number of problems here with the current procedure. First, to require these expensive studies to be done is costly, takes up time, imposes on somebody's speedy trial issues to go do a study like this. The Commonwealth has only been able to come up with one case in which it was successful, and that was with a grand jury. I have not seen any with similar facts where it's worked with the petite jury. The absolute disparity test is flawed. A person has, or a group has to represent more than 10% of the population in order for the absolute disparity test to work. That means that the predominant group in society is the one that would benefit from this test and not a minority.
So, excuse me, counsel, what is the trial judge supposed to do when a party says, I look at the veneer and I don't see, I only see one Black face in the back of the courtroom. And then the judge says, I see there are quite a few people who are medium toned, Asians possibly. What do you want me to do? So, and then the judge goes on to, he says he's not going to make a finding on whether or not the jury panel reflects accurately the population of the county because he doesn't have enough information. What should the judge have done differently?
Well, certainly the judge could have gone along with Attorney Tuohy's suggestion and, called another panel for the next day. That certainly would have been one option for him to do. As we get more jury panels, we would have seen statistical evidence that there were not Black members of the community. I mean, one just has.
How do we get that statistical evidence? Does the judge ask the jurors, are they Black, or what their race is? Does the questionnaire give their race?
Well, part of the problem has to do with the fact that we've excluded the issue of being able to observe what a person's race is. And if somebody was to come into court and say, you know, the person who mugged me was a Black person, that's allowed under our rules of evidence. We're allowed under our rules of evidence to make a determination as a layperson as to what a person's race is. You know, when you look at statistics, there are people who are, for example, in the US Census says that Hispanics could be white or Black. So we really have an issue of perception. You then have to look at issues.
But counsel, you may have concerns about that, but the SJC has offered guidance on the point, hasn't it?
There has been guidance on point. However, SJC.
And that guidance is binding on us, right?
I think that it's time for us to look at this issue again. The SJC.
Well, it seems to me that if you want to do that, they do that downstairs.
I think that the SJC's letter indicating that we need to be looking at how minorities are represented in our court system is a time for us all to reflect upon it. They didn't say
we can reflect as much as we like, but I, you know, I'm just a humble appeals court justice, and last time I checked, they get a little cross with us if we abrogate their precedent.
I would argue that their letter is a directive to relook at this problem. You know,
Well, so
yes and no, but I don't know that gives us license to disregard cases that they themselves have not overruled.
Is it your position that the trial judge should have asked the jury veneer what they considered their race to be?
You know, that would have been perhaps one option. However, people don't always accurately represent it. And when you look at the Harvard implicit bias test, it really is more how people perceive you in society versus what your actual race is, which is how you are treated and what affects your life experience. And
that may affect that. No, but that does not go to the question of a jury of one's peers. I mean, unless you're going to suggest that we must do a very closely calibrated measure of skin tone in comprising the juries in particular cases.
And given the mixed race of most Americans, that becomes a little bit difficult to do. It has to do with the perception that people have. When you take the Harvard implicit bias test, it really is all about how you perceive other people's race that affects their life experience and expresses their life. And then what they bring to the jury room, we're excluding something from the jury room that's very important in terms of a diversity of views. You know, but when we look at the statistical analysis basis, that doesn't work. The absolute disparity test doesn't work. And we certainly do allow people to look at people's race and observe people's race in other contexts as if they are testifying before the court. And yeah, those are, I think, very important things that we need to consider. And the SJC would not have written that letter of the 7 justices giving us a directive to make changes if that was not what they wanted to have happen. And perhaps it's just, since this hasn't come before them since then, you know, with the way Attorney Twohig had represented this and objected, then perhaps they haven't had an opportunity, and maybe it's an opportunity for this court to follow the justice's directive. You know,
they
basically
certainly have the opportunity to take from us directly cases that they identify, pending on our docket, that raise issues that they want to have something to say about.
And, you know, exclusion of individuals of a certain race within our jury pools, you know, really doesn't need a study. If it walks like a duck, it quacks like a duck, it's a duck. And at some point we have to recognize that, you know, this is a serious problem in our society that's affecting a lot of lives.
No question about it.
Pardon me?
No question about it.
I mean, we know that Black Americans are convicted at a higher rate than white Americans. We know Black jurors vote differently. We know that skin tone makes a difference in life experience. And those are all things that I think that the SJC was calling upon us to all make a change to.
Well, did the judges voir dire questions on race help to cure the issues that you're concerned about?
I don't think so, no. Because they were really left with a situation where they were pondering, is that one person Black or what are they? And, what people were. But
Well, the judge told the jury veneer that the defendant was Black and the victim was biracial.
Correct.
And he described briefly the allegations and asked if that would affect their ability to be fair and impartial. Did that do enough, or did that do anything to cure the implicit bias in the jury pool, or to weed out jurors who might be biased?
Well, the problem with implicit bias is that we don't necessarily know that we're biased. What the Harvard study shows is that we have biases that we're not aware of. And, that really is, part of the problem. Moving on to the issue of insufficient evidence, there's two problems there. One is the factual basis, I believe, was insufficient, as well as the element of force, I don't believe was appropriately proven. When we look at the testimony of the victim, we see or make a conjecture that Mr. McNeil's penis was in her mouth when she woke up.
Not a conjecture. Her testimony says that explicitly.
But then when she's questioned about this, she is asked, is there any reason your mouth would have been open? She talks about her sleep apnea. She talks about how she would stop breathing, how she gasps for air while she's sleeping, and her mouth is completely wide open and she snores.
So your suggestion is that under the Lattimore standard, we should disregard that statement in her testimony that that his penis was in her mouth when she.
No, I think that in fairness to the attorney for the Commonwealth, he then followed up with, what woke you up about something being in your mouth? And she says, I don't necessarily remember what it was that, well, I think I might have been choking. I mean,
Isn't
I don't
that
know.
interpretive question one for the jury that goes to the weight and not the sufficiency?
Well, I think she's very, very clear that she doesn't know what was in her mouth. She says, I was sleeping.
No, she's very clear that about what was in her mouth. She's very clear that she doesn't know what caused her to wake up.
She says, I was sleeping. I don't think any of us know what's happening when we're sleeping in dreamland.
No, but she said what the condition was when she woke up. She said that his penis was in her mouth when she woke up.
And when it was clarified by the DA, she said that she didn't know. And then she said when she woke up, what she saw was Greg standing in front of her. She said, I saw Greg standing in front of me. And I moved my face. His penis kind of scraped against my cheek. And I felt like a wetness. Then he sat down in the red chair and his pants were down and his penis was erect. What she saw was a man standing next to her with his penis hanging out and not his penis in her mouth. She was sleeping. She said she was sleeping. We're not competent to testify.
Can't the jury infer from circumstantial evidence that a moment before she woke up, his penis was in her mouth?
No, because it could have been his finger, it could have been anything, it could have been her sleeping with her sleep apnea. She didn't see it.
It could have been. It could have been any number of things that led to the penis being wet when it scraped against her, other than her saliva. But a jury permissibly could draw that inference.
Well, no, actually, this is really conjecture, I would say, and not something the jury's allowed to refer. They're not allowed to rely on conjecture and speculation, and that's
not conjecture, counsel. They've got a number of corroborating circumstantial contributions, including the physical position of the two participants and her testimony. I mean, but you can make the argument.
I think this is a classic case of the Commonwealth overcharging something. I think that, Mr. McNeil could have been convicted of a different crime, but not of rape. There is merely a conjecture that his penis was in her mouth.
As far as your argument on the issue of consent, are you saying that evidence was insufficient on the by force part of that, or the against her will part of it, or both?
Well, there's also the issue of force. which I think is problematic. The case law is basically vaginal rape. Vaginal rape does require some pressure, some force. Oral rape can be very different. And the
But
fact
only the
of this-
force necessary to accomplish the purpose.
Correct. It says only the force necessary to complete the purpose. It doesn't say no force. Her mouth was wide open. That means there was no force. If there's evidence that her mouth was closed and he opened her mouth, that would be some force. But she specifically stated that her mouth was wide open and she slept with her mouth wide open. That says there's no element of force. So I think
Do you have any case to support that assertion?
there aren't any cases directly on point on this that I've been able to come up with. I mean, the issue
Certainly are many cases involving a rape by force where it was an oral penetration.
Yes, but they all are situations where there was some force involved. This is a situation, I think, where her mouth was wide open. I think this is
all of them involve a circumstance where there was direct evidence talking about forceful opening of the mouth.
Right, and there was no forceful opening of the mouth in this.
No, but you just represented to me that all of the cases involving an oral rape involve a record that includes direct evidence of forceful opening of the mouth.
I have not come across any that would be right on point with these factual basis where the mouth.
Okay, thank you. Attorney Faraday for the Commonwealth.
Good afternoon. May it please the court. Assistant District Attorney Timothy Faraday from Middlesex on behalf of the Commonwealth. When we talk about force in rape cases, the element of force refers to the victim's ability to resist the rape and whether that was overborne. Since 1870, the SJC has logic that when someone is unconscious or asleep, like they were in this case, that the victim doesn't have the ability to resist, and that negates the element of force. So here, the only force that was required was the force that of the penetration in this case, which was the defendant placing his penis in the victim's mouth, moving his penis into the victim's mouth. And that is sufficient under the case law since 1870. And under Burke, it was reaffirmed in Helfant after the common law was codified, and is still the law of the Commonwealth following Blanche, which modified the instruction. And here there's also more than sufficient evidence of penetration. The victim directly testified that she woke up and his penis was in my mouth. She continued, I don't know, I might have been choking. I mean, I don't know, I was sleeping, but I felt this in my mouth and I woke up. Under Santos, the recent decision of this court, the victim's testimony alone is sufficient in a sexual assault case. Turning to the issue of the representation of the jury, I want to point out a couple of things from Arriaga. First, that in Arriaga, Justice Ireland's opinion in that case, the SJC said that pursuant to our supervisory power, we direct the jury commissioner to amend the jury confirmation form as soon as practical to require the submission of information about the juror's race and ethnicity. And that was in 2003. So my sister's argument that it's going to be too difficult to do these statistical studies, I think, is conjecture without any actually effort to see if the statistical analysis could be done. Arriaga was in 2003, and I don't think there's been any effort made in this case to actually contact the jury commissioner, get the information about racial and ethnic makeups of jury pools in Middlesex County and do the statistical analysis required by Arriaga. I think it's important, if we're going to say that there's a problem in our jury selection, that we actually find out what the problem is. I point out in my sister's reply brief, the last thing she says on page 25 of her reply brief is this matter should be reversed or remanded for a new trial with orders to correct the procedures that have led to the lack of diversity and underrepresentation of Black Americans in the jury veneers. I think it's important to point out she hasn't actually identified which procedure needs to be corrected and gives no guidance to this court of how she wants the case to be remanded. Or even that African Americans were underrepresented in this venire or veneries in general in Middlesex County. I'd also point out under Arriaga, when we talk about the absolute disparity test, Justice Ireland stated that the absolute disparity test will not be applied mechanically, but rather consider the evidence of disparity in light of the circumstances and the size of the population in question. Evidence of disparity smaller than 10% can support a conclusion of unconstitutional underrepresentation of smaller minority groups, especially when coupled with persuasive evidence of systematic exclusion. And I think that undercuts my sister's argument that when a group is under 10%, it would be impossible to apply the absolute disparity test when the SJC has said that that test is not going to be applied mechanically in this Commonwealth. And there's been no effort to actually prove the underrepresentation. I think my sister makes very good points, and I think the SJC's letter makes very good points that the representation of jury venaries is extremely important, and they should represent a cross-section of the community. But before we say that there is a problem, the problem has to actually be identified. And if there are any other questions, I'd be happy to take them. And if not, I'd rest on my brief.
Being none, I will take the case as submitted, and that will conclude the argument in this case, as well as our session on the whole. Thank you both.